All right, everyone, if we could collect ourselves, thanks so much for coming today. It's a great turnout. I'm happy to see this. And welcome to our 9th Federalist Society event of the year and our 5th one of the semester. For those of you who don't know me, I'm Richard Benson, second-year law student here at Maurer, and I've had the absolute pleasure of being the president of the chapter for this academic year. It's been a banner year for us with a record number of events, and Nationals noticed by giving us the Hamilton Award for the Most Improved Chapter. I would like to take a moment to thank my board, Alex Uli, Julia Payne, Emmanuel Chioco, Mark Riffle, and Paul Neuendijk, as well as my great 1L reps this year for those who allowed us to succeed. This is my last event as president, and I am happy to hand the chapter in good shape over to Jonathan Fox, who will take over as president with a great board next year, and they will continue the promise to not have any pizza for our events. The Federalist Society believes in debate and dialogue and promotes that in law schools by bringing excellent, highly skilled, and learned voices from the conservative and libertarian perspectives to engage with a mostly leftward polity. It is our belief through this engagement that we actually gain more knowledge as future lawyers and are able to appreciate different sides of an argument better than we would through just regular classes. In that spirit of dialogue, I am especially grateful for our co-sponsors of today's event. First, I'd like to thank the Labor and Employment Law Society, which helped contribute to the good food, as well as our friends on the other side of the ideological spectrum, Law Students for Reproductive Justice. For our last event of the year, we wanted to finish with a lively topic with two experts in the field debating. It so happens that the Supreme Court heard a case last week of Zubik versus Burwell, a case in which the Little Sisters of the Poor, an order of nuns, insist that having to declare their religious objection to the HHS contraception mandate in the Affordable Care Act violates their religious liberty. But far from the specific facts in this case, greater questions arise about the intersection of religious liberty and healthcare rights, privileges, and government involvement with the same. Fundamentally, how far should the much-debated decision of Hobby Lobby be carried in the employment sector? Today's event is structured like a formal debate with equal speaking time for both sides. We'll begin with about 20 minutes with Dr. Anderson, then it'll go until about 12:30, and then about 20 minutes as well for Professor Sanders for their cases in chief. At that point, if you have legal professions for the 1Ls, you can leave at the end of the second main speech. We'll have about 5 minutes of rebuttal time for each side, and then we'll close with any Q&A from the audience. As a final administrative note, if you're a practicing attorney needing CLE credit for the hour, the CLE sign-up sheet is in the center back there for you. Now on to our debaters today. We have two fantastic voices on this subject. I'll introduce them in reverse speaking order and then get out of your hair. Speaking second today will be Steve Sanders, an associate professor of law here at Maurer and also an affiliate faculty for the Department of Gender Studies and the Kinsey Institute for Research of the Gender, Sex, and Reproduction and the IU Department of Political Science. Professor Sanders teaches constitutional law and litigation, as well as family law, and has been on the Maurer faculty since 2013. He's very active in scholarship relating to the legal needs of same-sex couples. Professor Sanders received his bachelor's degree here in 1984, and then later his JD from Michigan in 2005, clerked for Judge Evan on the 7th Circuit, worked for Mayor Brown in the Chicago office for the Supreme Court appellate litigation, and has taught at the University of Chicago and Michigan law schools. We appreciate Professor Sanders' eagerness to engage in debate with many discussions this year and look forward to many next year. Please welcome Professor Steve Sanders. And as for our first speaker, today's guest who just flew in from Washington, Dr. Ryan T. Anderson. Dr. Anderson is the Heritage Foundation's expert on religious liberty, marriage, life, and the family, and serves as the William E. Simon Senior Research Fellow in American Principles and Public Policy. His book, What is Marriage?, was cited twice by Justice Alito's dissent in the Windsor case, and then later by Justice Thomas in the Obergefell case. Dr. Anderson received his bachelor's from Princeton, graduating magna cum laude and Phi Beta Kappa. He then went to Notre Dame, receiving a master's degree and then a doctorate in political philosophy. Anderson has appeared on a litany of news media programs as well as newspaper columns and is currently writing a book for Oxford University Press on religious liberty. Originally from Baltimore, Dr. Anderson resides with his family in Washington, D.C. Please welcome to the podium, speaking for 20 minutes in defense of Little Sisters of the Poor, Dr. Ryan Anderson.
Great. Thank you. Thank you for that warm introduction, and thank you to Professor Sanders for agreeing to do this debate. About this time last year in D.C., Professor Sanders and I did a debate on the Obergefell case. Everyone said I won the debate, but he obviously won the case, which seems to matter more. And thank you all for coming. This is great to be here for a large audience. What I want to do in the 20 minutes I have is cover 4 issues. I'm going to go through sequentially. First, talk about a little bit religious liberty, what it is, why it matters, what the founders thought about it. Second, Religious Freedom Restoration Acts, what they are, what they do. Third, the HHS mandate. And then fourth, applying the RFRA framework to the HHS mandates. This is going to be applying it to the Little Sisters case. So the first part, religious liberty. America is founded to protect various civil liberties. Among them is the right to the free exercise of religion. We have not always honored this right that we've sought to protect, right? So the pilgrims come here and then they start immediately persecuting non-pilgrims. Plymouth County is set up and then they start persecuting other religious minorities. We flee religious persecution in Europe and then we start persecuting other people who we disagree with. So when Roger Williams leaves Plymouth County to go to set up Rhode Island, he then starts, Rhode Island starts persecuting Jews and Catholics. Maryland's founded as a safe haven for Catholics, and within 2 generations, Catholics can't vote or hold office. Pennsylvania's established to protect Quakers, and within a few years, they can't vote. So we don't always honor this, and yet it's been one of our animating ideals. And the idea here is that religious liberty isn't just the grant of a sovereign. It's not a mere matter of toleration, but it's a limit on government because it's a natural right. So what I want to do in this first section is just read 2 quotes, one from George Washington, one from James Madison, to kind of tease out what the founders were getting at and why this matters as a matter of justice. So Washington writes a letter to the Hebrew congregation of Newport, Rhode Island. And remember the history of what I just mentioned in terms of how the Jews were treated in Rhode Island. He says, quote, "The citizens of the United States have a right to applaud themselves for having given to mankind examples of an enlarged and liberal policy, a policy worthy of imitation. All possess alike liberty of conscience and immunities of citizenship. It is now no more that toleration is spoken of, as if it were the indulgence of one class of people that another enjoyed the exercise of their inherent natural rights. For happily the government of the United States gives to bigotry no sanction, to persecution no assistance, requires only that they who live under its protection should demean themselves as good citizens." End quote. So think about what Washington's saying here. He's saying to the Hebrew congregation in Newport is that we're not just going to tolerate you as if you're something bad that we're putting up with, that we're conceding something to you because it's a concession that the sovereign is making on your behalf. No, in the United States, you have natural rights, including a natural right of conscience and a natural right to worship in accordance with your own beliefs. And provided you uphold yourselves as good citizens, we're not going to be harassing your natural rights at all. Madison, the theoretician, explains why. So in the Memorial and Remonstrance, Madison makes a syllogistic argument, a natural rights argument, as to why the free exercise of religion is one of those natural rights that the U.S. government should be protecting. He explains, quote, "Because we hold it for a fundamental and undeniable truth that religion, or the duty which we owe to our Creator and the manner of discharging it, can be directed only by reason and conviction, not by force or violence. The religion, then, of every man must be left to the conviction and conscience of every man. And it is the right of every man to exercise it as these may dictate. This right is in its nature an unalienable right. It is unalienable because what is here a right towards men is a duty towards the Creator. It is the duty of every man to render the Creator such homage and such only as he believes to be acceptable to him. This duty is precedent both in order of time and in degree of obligation to the claims of civil society." End quote. So what's Madison saying here? He's saying that there's a vertical relationship here with the individual owes to a Creator. And however you answer that question, whether you think there's a Creator or not, whether you think you actually owe a duty to that Creator or not, how you think you're supposed to discharge that duty to the Creator, it's all left up to that individual. And that duty, therefore, places limits horizontally. The vertical duty places limits horizontally on what other people can claim of you, on what civil society can claim on you. And so Madison's argument is that duty takes precedence both in the degree of obligation and in order of time to anything that the state could claim of you. And so that's what starts setting up the theorizing behind the various bills protecting conscience, protecting religious liberty. It informs the First Amendment and informs various other practices for the founding era government in terms of exemptions and accommodations. Fast forward about 200 years to 1993. So this is the second part, the Religious Freedom Restoration Act. Here you have a bill that's unheard of today in our partisan politics and unheard of today in our Congress. It passes unanimously in the House of Representatives, being sponsored by then Congressman Chuck Schumer. It passes with 97 votes in the U.S. Senate, being sponsored by Senator Ted Kennedy. And it's signed into law by President Bill Clinton. A few years later, it's beefed up with the Religious Land Use and Institutionalized Persons Act. So whereas you have RFRA, this is RLUIPA, to protect the rights for religious liberty for prisoners and for various land purposes. These two laws have now been used in the past 20 years to protect Apache Indians who were told they couldn't wear headdresses with eagle feathers, to protect Sikhs who were told they couldn't carry the kirpan to their government jobs, to protect Santeria priests prevented from performing sacrifices, Muslim prisoners forbidden to grow a 1/2-inch beard, Jewish inmates who were denied kosher meals, and inner-city black churches that were being zoned out of existence. A parade of a variety of religious beliefs, some of which you may agree with, some of which you may not agree with, some of which you may never even heard of before, that this law instituted a heightened sense of scrutiny to make sure that if the government substantially burdened these beliefs, it was only doing so for the most compelling of reasons. Clinton explains why he signs RFRA into law with a signing statement. He says, this act reverses the Supreme Court's decision in Employment Division v. Smith and reestablishes a standard that better protects all Americans of all faiths in the exercise of their religion in a way that I'm convinced is far more consistent with the intent of the founders of this nation. He then continues, quote, the free exercise of religion has been called the first freedom, that which originally sparked the development of the full range of the Bill of Rights. Our founders cared a lot about religion, and one of the reasons they worked so hard to get the First Amendment into the Bill of Rights at the head of the class is that they well understood what could happen to this country, how both religion and government could be perverted if there were not some space created and some protection provided. They have seen now, all of us, that religion and religious institutions have brought forth faith and discipline, community and responsibility over 2 centuries for ourselves and enabled us to live together in ways that I believe would not have been possible. We are, after all, the oldest democracy now in history and probably the most truly multi-ethnic society on the face of the earth. And I'm convinced that neither one of these things would be true today if not for the First Amendment. And then he concludes, what this law basically says is that the government should be held to a very high level of proof before it interferes with someone's exercise of religion. This judgment is shared by the people of the United States as well as by the Congress. We believe that we can never be too vigilant in this work, end quote. So you think about what President Clinton was getting there. He says, look, religious freedom places limits on what the government can do. It helps protect pluralism and diversity. He says we're the most multi-ethnic nation in the world because we have 200 years of protecting religious freedom for a vast variety of religious beliefs and practices. And then lastly, and it creates the space for civil society to do the work that it needs to do, forming faith, discipline, community responsibility in non-governmental institutions. In other words, this is everything that the Little Sisters embody. They're simply asking to be free from a government coercive mandate so that they can live by their peculiar beliefs. It's widely understood that less than a couple % of Americans actually agree with the Little Sisters' belief concerning contraception. And so that then they can be one of the civil society groups that takes care of the least among us. The Little Sisters are a celibate order of Roman Catholic nuns who pledge their lives to take care of the elderly poor as they die. And all they ask is to be left free from this mandate to continue doing this work. The president of the ACLU at the time that RFRA was being considered in Congress testified in support of RFRA. And she said that this statute would safeguard, quote, such familiar practices as, quote, permitting religiously sponsored hospitals to decline to provide abortion or contraception services, end quote. All the Little Sisters are asking is for RFRA to protect them from having to cover abortion and contraception services. So let me go on to what the mandate does. So the third part, HHS mandate. So a part of the Patient Protection and Affordable Care Act said that the Department of Health and Human Services would come up with various lists of mandated drugs and devices for various purposes, one of which was a preventative care mandate that lists 20 FDA drugs and devices, 4 of which the FDA labels as having the capacity to cause early abortions. It says that all 20 of these drugs and devices must be covered cost-free in every employer-offered plan. Sensing that this would cause religious liberty concerns, the Department of Health and Human Services fully exempted houses of worships and, quote, their integrated auxiliaries, which would be a church-run shelter or a church-run soup kitchen. They did not exempt other religious nonprofits that are similarly situated. To them, they gave an accommodation. It's gone through about 5 or 6 different iterations now, which tried to put distance between the healthcare plan that the employer offered and the coverage of these drugs and devices. Each and every time what they've ultimately done is just given a different way in which the nuns can violate their beliefs. They have not yet actually exempted the sisters. Let me explain why by going through the 4-pronged analysis of RFRA. What RFRA says is that the government can only substantially burden a sincerely held religious belief if it does so for a compelling government purpose in the least restrictive way possible. So those are going to be the 4 prongs. First, sincere religious belief. Does anyone doubt that the nuns have a sincere religious belief when they oppose abortion, contraception, and sterilization? This has been standard Catholic teaching for about 2,000 years now. The nuns have been operating this way since their founding. They don't do euthanasia or other what they would view end-of-life treatment that violates the sanctity of life. The same thing is true for the archdioceses that are suing the Obama administration. The same thing is true for the seminaries that are suing the Obama administration, for the religious colleges, for the orders of missionaries. The sincerity of their religious belief and their objection hasn't been questioned by anyone, including the federal government. The Obama administration has said on the sincerity part, you get a pass. Second question is there a substantial burden here? Substantial burden analysis is going to be, will the government force you to do something you say you can't do, or are they preventing you to do something that you say you must do, and are they then backing it up with a substantial penalty? So the Little Sisters are saying we can't have our health care plan hijacked by the government and be the one that triggers the coverage of drugs and devices that violate our religious beliefs. And if we don't do this, the government is saying we will be fined $70 million per year. So there's something that they can't do. It's a sincere belief, and it's backed up by $70 million a year in fines just for the Little Sisters. You look at the other plaintiffs in these cases, and it's hundreds of millions, if not billions of dollars in fines. They don't object to opting out. Some people have argued that they're objecting to objecting. No, they say we would be fine to opt out. What we object to do is fill out an ERISA form, it's Form 770, which would be the trigger for the government to then hijack our health care plan and inform either our insurer or our third-party administrator to provide precisely the drugs and devices that we object to our employees. The government itself has said that this is, quote, another way of complying with the mandate. They're not exempting the Little Sisters. They're not exempting Catholic Charities, at least not Catholic Charities of Pittsburgh. They are exempting Catholic Charities of Erie, Pennsylvania. What's interesting here is that they didn't use Title VII, which is congressional statute for religious freedom that actually defined which nonprofits would be exempted from the Civil Rights Act for the purpose of religious hiring. What the Obama administration did was use an irrelevant form of the tax code on who has to file an informational tax return to decide who would qualify for the exemption. So the plaintiffs point out that similarly situated petitioners here, Catholic Charities of Pittsburgh, Catholic Charities of Erie. In Erie, Catholic Charities is exempted from this mandate. In Pittsburgh, they are not. And they ask the government, explain why. What is the difference? So you go to the compelling state interest here. It's unclear how the government can say that there's a compelling state interest in saying that the employer, the Little Sisters health care plan must provide coverage for these drugs and devices when 1/3 of all Americans are in plans that are exempted from this mandate. Either because of the grandfathered status or because of the exemption to churches and houses of worship, 1/3 of all Americans are not on a health care plan under the HHS mandate. What sort of interest counts as a compelling interest? So in the Sherbert case, the Supreme Court said a compelling government interest is, quote, paramount interests that protect against, quote, the gravest abuses. The Yoder case, the Supreme Court said that they are, quote, interests of the highest order. These are the sorts of interests that justify overriding constitutional rights. So then in 1993 in the Church of Leukemia, and then in 2006 in the O Centro case, the Supreme Court said a law cannot be regarded as protecting an interest of the highest order when it leaves appreciable damage to that supposedly vital interest unprohibited. So if the coverage of these drugs and devices is in fact a compelling state interest, why have they exempted Exxon and Chevron and Pepsi and the U.S. military, which is the largest employer in the United States, from having to cover these drugs and devices? And why do they refuse to exempt the Little Sisters of the Poor? Because the compelling state interest analysis here isn't just an abstract compelling state interest, but it's a compelling interest as applied to the petitioners. So how would exempting the nuns and their health care plan cause a violation to this compelling state interest when exempting Chevron and Pepsi and Exxon and the U.S. military does not? Or how is exempting Catholic Charities of Pittsburgh causing harm to this compelling state interest when exempting Catholic Charities of Erie does not? What is the legally relevant distinction for why you exempt one and you exempt the other if it's truly a compelling state interest? The last thing I'll say is the least restrictive means test, the fourth prong of the RFRA analysis. If you do say, look, there is a compelling state interest as applied to the Little Sisters of the Poor, are there less restrictive means of accomplishing it? So one of the first things you're going to say, well, wait, you've exempted the churches. So how are all the employees of the churches and the employees of Catholic Charities of Pittsburgh, how are those people receiving this essential service? Couldn't you also exempt the nuns, and whatever you're doing for those other employees, provide to the employees of the nuns? Wouldn't you be able to offer them health care on the exchanges? You've just set up this massive new health care entitlement. Wouldn't that be a less restrictive way of accomplishing this? If not the entire health care plan, what about a contraception-only supplementary health care plan on the exchanges for people who work for an employer with a sincere religious belief? How about Medicaid reimbursement? How about direct reimbursement? If you show up at a pharmacy and they say, look, your insurance card doesn't cover this, it automatically triggers the U.S. government to pay for it. Because after all, under the accommodation that the government says, they say that the Little Sisters aren't paying for this. They already said that none of the Little Sisters' money is going to pay for this. So whoever is in the ether actually paying for this, why couldn't that be triggered right at the pharmacist's office and leave the Little Sisters out of it? If not that, you could have tax subsidies. You could have Title X family planning clinics, which already exist all throughout America, be there to provide these drugs and devices. The government has the burden on a RFRA analysis to provide proof that what it's doing is for a compelling state interest in the least restrictive way possible. And in this case, the government has provided next to no proof. They haven't even attempted to do this, partly because I think they know that they would fail. So instead, where they have focused their charges saying that there's no substantial burden at all. And so I know ahead of time that that's where Professor Sanders is going to be focusing his remarks. So I'm going to turn over the podium and allow him to make that case. Thank you.
Thanks, Ryan. And as Ryan said, I still have very fond memories of the debate we did in D.C. last year. I would say, though, if he thinks that everybody thinks he won, it's because the debate was held at the headquarters of the Daughters of the American Revolution, and the audience consisted of all the members of the mailing list of the Alliance Defending Freedom in Washington, D.C. So it must be said he had a friendly crowd. Ostensibly, these cases, the Zubik cases, are about religious nonprofits and the government. But religious liberty claims frequently come at a price to third parties. So let me begin with a few observations about the people whose rights are largely going unmentioned in this litigation and this debate: women. More than 99% of women aged 15 to 44 who have ever had intercourse have used at least one contraceptive method, and 62% of women of reproductive age currently are using a contraceptive method. The origin of the Affordable Care Act's contraceptive mandate comes not from politicians, but from a report by medical experts, the Institute for Medicine, part of the National Academies of Science, which concluded that contraception is a basic part of an approach to health care that is aimed at prevention. prevention. Almost half of all pregnancies are actually unintended. Many of these involve premature births or other birth problems. Women with unintended pregnancies are more likely to receive delayed or no prenatal care, to smoke, to consume alcohol, to be depressed, to experience domestic violence. Unintended pregnancies also increase the risk of babies born preterm or low birth weight, both of which increase their chances of health and developmental problems. And so access to contraceptive counseling services and products is a basic part of a comprehensive system of health care for women. It's also been basic to the equality and civil rights of women. 2004 Guttmacher Institute report concluded that women who can successfully delay a first birth and plan the subsequent timing and spacing of their children are more likely than others to enter or stay in school and to have more opportunities for employment and full political and full social and political participation in their community. In 2000, the EEOC ruled that companies that provided prescription drugs to their employees but didn't provide birth control were in violation of Title VII, which prevents discrimination on the basis of sex. Even before this federal mandate was implemented, 28 states had their own mandates that required health insurance to cover prescription contraceptives, and 90% of employer-based health insurance plans do offer contraceptive coverage. Bottom line, access to contraception is part of responsible health care, and it's also essential to the legal and social equality of women. It does serve a compelling interest. Okay, so much for the rationale behind the policy. What's the case for religious exemptions? Well, first, remember, Congress in the ACA, the people we actually elect to make policy and to make these decisions, provided zero religious exemptions in the ACA, none, even though Congress obviously knew how to do so because many federal laws already incorporate religious accommodations. Congress could have chosen to give the sort of complete exemption that Ryan wants to the sort of religiously affiliated nonprofits who are the petitioners in Zubik. Colleges, for example, Catholic charities. And if Congress had done so, there'd be no need for us to be here today. The case for exemptions isn't great. I think religious colleges employ tens of thousands of people. Catholic Charities has a budget of $4.5 billion, making it the 15th largest charity in the country. Many of the people who work for these nonprofits are not of the same religious affiliation, and even if they are, they don't subscribe to the same beliefs. Point is, though, Congress could have given these exemptions. Congress didn't. The executive branch, the Obama administration, thought there was a clear case for totally exempting churches and other houses of worship. This makes sense, and I think it's consistent with First Amendment values and jurisprudence. In addition, the executive branch, the Obama administration, went further. It did create a mechanism by which these nonprofits could disassociate themselves from underwriting any cost of providing contraceptive services through their insurance plans while ensuring that women would still have the services available. To do so, the nonprofit does nothing more than submit the simplest of forms, alerting the government that it has a religious objection to providing such coverage. This triggers a process whereby the insurance company arranges to provide the coverage that is paid for by the insurance company, not the employer. The insurance company can easily do that. It can expect to recoup the cost through lower expenses for pregnancy medical care. And if the employer is self-insured, the coverage cost is actually reimbursed by the federal government. So the issue pending before the Supreme Court boils down to quite simply this: is a requirement to file a simple piece of paper alerting the federal government that you are claiming a religious accommodation in itself a violation of your religious liberty under RFRA. Petitioners and Ryan say yes. They say merely filing this form makes them complicit in sinful activity. It would be material cooperation, the petitioners say, that would facilitate the wrongdoing of others, tempting them to engage in immoral conduct. And so, as Justice Scalia might have said, it has come to this: a reasonable accommodation that is by no means constitutionally required, and which is intended to protect religious liberty while also protecting the rights of third parties, is itself condemned as a violation of religious liberty. Because this accommodation absolves the organization of any obligation to pay for the services. The Little Sisters do not have to cover, to use Ryan's term, any of these services. There is no cost imposed on the nonprofit organization. But in the end, what the nonprofits object to is the fact that at the end of the day, their female employees will still have access at someone else's expense to contraceptive services. They seek a complete exemption from the mandate because that would empower them to completely deny contraceptive services to their female employees. Now, I think there can be two possible reactions to this. One is you can't be serious. This is simply a way to fight Obamacare by other means, and it's intended to exact as much damage as possible against the principle that women have a right to contraceptive coverage. I have a hard time accepting the argument with a straight face, but let's give it the benefit of the doubt and assume that it is sincere. If these organizations are serious in their religious conception that signing and filing this form that triggers their insurance company's obligation to cover the contraceptive services, if that is a substantial a substantial burden on the free exercise of religion, then their claims must fail because accepting their theory would render the careful balance that Congress intended to provide under the federal RFRA to be completely unworkable. The petitioner's claims are based on an absolutist view of what counts as legally protected religious exercise, together with an insistence that courts are categorically forbidden to independently assess what counts as a substantial burden on religious exercise. According to the petitioners, a religious exercise is any act or omission motivated by religious belief, and law cannot treat some instances of religious exercise as more important, significant, or substantial than others. That's well established in First Amendment doctrine. But here's the kicker. The petitioners also say judges are absolutely forbidden from evaluating whether the claimed injury here to religious belief is simply too far attenuated from the challenged government action, filing a form, to be considered as a matter of law a substantial burden. The petitioners absolutely insist that courts may not make that inquiry, may not think of this as a proximate cause problem, because that in itself would deny the validity of their sincere religious belief. The petitioner's argument in this case takes, I think, religious liberty claims past any notion of the kind of interest balancing that Congress intended under RFRA, and which is inherent in all religious accommodations, past any notion of reasonable accommodation, perhaps even past the point of absurdity. It's a demand not for substantial deference to the religious believer, but for absolute government deference. It's a demand that courts abdicate any role in measuring infringement on religious belief against the needs of the government or the rights of third parties, i.e. women in this case. It effectively makes any claim about religion completely non-justiciable. It makes the religious believer a law unto himself or herself. The objection to the petitioner's argument, I think, can't be just dismissed. Well, Sanders, you're just making a slippery slope argument. I don't think that's the case. I think here there truly is no logical stopping point to the petitioner's position. The petitioners could use this exact same rationale to object to employees receiving stem cell treatments or treatment for HIV when it was contracted through gay sex. An employer who's a Jehovah's Witness could object to his employees receiving any medical treatment involving a blood transfusion. What if an employee informed her employer that she planned to use part of her paycheck to purchase a contraceptive? The employer knows to a moral certainty that its money is going to be used to purchase contraception services. By their logic, the petitioners would have to fire that employee because they would be in a contractual relationship that facilitates the ultimate availability of contraceptives. That is exactly the objection they say they have to the regulatory requirements of the ACA mandate. I would submit in a diverse, pluralistic society, we can't abide this kind of religious absolutism. It cuts against the values of pluralism and reasonable accommodation and space for diverse views that Ryan talked about. Yes, RFRA passed with an overwhelming majority of bipartisan support, but now that many of those members of Congress are seeing the way petitioners are using the RFRA and the way the Supreme Court is interpreting it, people like Charles Schumer are saying, whoa, this is not what I signed on to. you, we never imagined RFRA going this far in changing the nature of religion jurisprudence. In no other area of law do we tolerate such unilateral power whereby one party claims the absolute authority to determine, by reference to unilaterally determined and non-justiciable principles and beliefs, the rights of some other person. As Garrett Epps, a law professor and Atlantic commentator, wrote, this argument in Zubik is an example that religious freedom has morphed from a shield defending the meek into one more sword demanding obeisance to the haughty. To be clear, the petitioners have no First Amendment claim here. An Employment Division versus Smith, an opinion of the Rehnquist Court written by the Federalist Society's favorite justice, Justice Scalia, a conservative-dominated court said decades ago that the First Amendment's free exercise clause did not and cannot mean the religious motivation for an action places the actor beyond the reach of ordinary laws. Relying on cases going back to 1879, the court said laws are made to govern actions, and while they can't interfere with religious beliefs or opinions, they may interfere with actions and practices. To permit otherwise would be to make the professed doctrines of religious belief superior to the law of the land, and in effect to permit every citizen to become a law unto himself. But that's exactly what the petitioners, in this case invoking the federal RFRA, really seek, to be allowed to act as laws unto themselves with no regards for the needs for democratic government or the interests of third parties. Since the inception of the federal RFRA, one of its most consistent and stalwart defenders has been Professor Doug Laycock of the University of Virginia Law School. And if you don't believe me, ask Professor Conkle, one of his good colleagues and friends. In a RFRA case, you could almost always expect to see a Laycock brief on the side of the religious group and know that by this court it would be taken seriously. You do not want to be on the opposite side of a RFRA argument from Doug Laycock. Well, in this case, Professor Laycock filed a brief on behalf of the government, not the religious nonprofits. Even he says in this case the petitioners have gone too far in their arguments. Suppose, he tells the court, that a believer sincerely believes that his religion prohibits him from submitting to the authority of any government that permits abortions. He cannot obey its laws, pay its taxes, or give it information about his business. On the petitioner's theory, he says courts would have to owe absolute deference to that claim of a substantial burden. Petitioner's theory of absolute deference to religious claims, he says, would lead to absurd results that would discredit RFRA and the cause of religious liberty. It would increase the political pressure for repeal or damaging amendments to both the federal RFRA and many state RFRAs. The petitioners are wrong, Professor Laycock says, in arguing that the question of substantial burden under RFRA is not a justiciable question. They're wrong, he says, that Congress or administrative agencies cannot set boundaries on religious accommodations, even if some nonprofit groups don't like where the line has been drawn. And they're wrong, he says, in arguing that filing a piece of paper to claim a religious accommodation is in itself an impermissible burden on religious liberty. In his follow-up comments, I hope Ryan would address the following hypothetical. Imagine a woman who's told that the child she carries will have a profound developmental disability and will never have anything resembling a normal life. Further, imagine that this woman's sincere and unchallenged religious conviction demands that she not put such a child into the world. And even though she's past the point of viability and her state outlaws abortion at this point, she is entitled, as a matter of her religious liberty, to abortion. To deny her would be to impose a substantial burden, not just of carrying the child to term, but of potentially crushing financial and emotional consequences. Would you defend the right of such a woman to have her sincere religious belief prevail over the government's law to the contrary? Consistency with the arguments in Zubik mean that you must. I don't see a way out of this. You may disagree with the validity of the religious belief, or you may take a different moral view of the matter, but the Zubik petitioners make a strong case that neither of those can be the basis for a court to deny a religious claim. Now, there is a way out of this. Under RFRA, government can still prevail over the religious believer if its law serves a compelling interest, as Ryan described. I suspect that Ryan would resolve the hypothetical I've suggested by responding that the government has a compelling interest in preventing abortion, but not a compelling interest in safeguarding the health and equality of women by assuring their access to contraceptives. But that's merely his opinion. Such an answer would seek to end the argument by imposing a normative value judgment about what government interests are and are not compelling. It does not honestly grapple with the extent or the logical stopping point of the argument about religious belief and substantial burden that the petitioners in Zubik are making. What is and is not a compelling government interest is in the end the sort of heavily value-laden policy question that legal conservatives, like members of the Federalist Society, usually say we should avoid having judges decide if at all possible, because when they do, they are inevitably making normative judgments based on highly contestable assumptions and prejudices. Ryan and the plaintiffs, the petitioners in Zubik are saying, well, the court should require the Obama administration to send the people out on the exchanges or refashion it into a Medicare reimbursement system. I thought that the Federalist Society and legal conservatives generally oppose that kind of Lochnerism, oppose that kind of second-guessing by courts, rewriting by courts of legislative and executive government judgments. But it seems as though sometimes conservatives get enthusiastic about that kind of thing when it serves their interests. Finally, you may say just make the religiously affiliated nonprofits, give them the same exemption as the churches and the houses of worship. But once again, it's not that simple. Under a total exemption, the organization's insurance companies would not be required to provide any contraceptive services to women. That is the price that would be paid for this religious accommodation. But aside from that, once again, that's a policy argument to be made to Congress, not to the courts. The Federalist Society is supposed to be about the limited role of courts and is supposed to dislike the courts making legislative policy, which is what the court would be doing here if it accepts the petitioner's arguments. Remember that religious exemptions to general laws like the ACA are in no way required by the Constitution. They're often provided as compromises made through the legislative process. But I would close with the words of, once again, Professor Laycock. There are thousands of religious exemptions in U.S. law. If legislators and administrative agencies can't enact a narrow religious exemption without it being expanded to become all-inclusive, many of them will not enact any religious accommodations at all, and they'll start repealing exemptions they've already enacted. These arguments may offer the best chance to win this case, but they would do terrible damage to the larger cause of religious liberty. A ruling for these religious plaintiffs would make things much, much worse. So, thank you.
Wonderful. So there's a lot there to respond to because a lot of what was said is just factually inaccurate, both about what the HHS mandate does, how ERISA works, and about the views that I supposedly hold or that the Federalist Society supposedly holds. So I'll start by saying FedSoc is not against judicial review. So when there is a statute that Congress has passed, that it says Congress has to abide by this statute, it is the appropriate role for judges to say whether or not Congress or the executive branch of government has in fact abided by that statute. There's nothing wrong with, at one point the Chief Justice during oral arguments actually chided the Solicitor General saying, well, that's what we do all the time. We strike down laws. And if the law or the policy or the regulation that you are implementing violates a more fundamental law, whether it's a constitutional provision or a statutory provision, we have the duty to strike it down as applied to the petitioners. FedSoc is totally okay with that. And so the question here isn't one of legislating from the bench. It's saying here are all the other options that you, the legislative branch and the executive branch of government, have at your disposal that you chose not to use, and yet the statute says you have to use them if they are available. They're not legislating from the bench. What they're pointing out to is that the government didn't use the least restrictive means possible. So working back from that last comment of Professor Sanders to his hypothetical, yes, if a state was to say, that there is a compelling state interest in protecting innocent human life from killing, and that they were saying the least restrictive way of this, that we're not concerned with too much innocent human life being killed, but any innocent human life being killed, then they would say that the RFRA challenge would fail. To say that you have a sincere religious belief, it may very well be a sincere religious belief. And undoubtedly, an abortion regulation would impose a substantial burden. But as the ACLU itself admitted when RFRA was being discussed and passed into law in 1993, it would not cover a right to abortion. The ACLU itself made that point. So when you ask me, what would be my response would be the ACLU's response. That the compelling state interest here is the right to life. And the least restrictive way here is not too much violations of the right to life is the concern, but any violation. So you look at our laws against murder, we don't exempt 1/3 of all people from the laws of murder. So if we had a similar regulatory scheme as applied to abortion, then you might be able to raise the RFRA challenge, which goes back to Doug Laycock's brief. Doug has now admitted on a public listserv that if the HHS contraception mandate works in the way in which the Little Sisters argue it does, then he is not opposed to their claim. And he's admitted that he's not an ERISA expert. But the ERISA experts, including the federal government, have said that it works exactly the way that Little Sisters say, which is why they're insistent that they fill out this particular form. Because the federal government knows that the Little Sisters object. The Little Sisters have had no problem objecting. So they're not objecting to objecting. It's that the specific form that the government wants them to fill out is the form that then legally triggers the federal government to hijack their health care plan. Without this form, the federal government has no legal authority to hijack their plan and to mandate coverage of these drugs and devices. So it's not simply filling out the simplest of forms that registers an objection. It's a way of complying with the mandate that they object to. They haven't been exempted or accommodated at all. That has been the point they've been making since the beginning. Professor Sanders would say, look, Thomas More, all you have to do is fill out a little form. What's the big deal? Thomas More chose to go to the scaffold instead, because sometimes filling out a little form has eternal consequences. So Professor Sanders is suggesting that a Little Sisters claim is so ridiculous we shouldn't even entertain it. And yet throughout history we have seen people who have been martyred precisely because of filling out a little form or burning a little incense. So I think what this shows is precisely what the federal courts have insisted that they should not do. The government should not be judging someone's religious belief. You can think the religious belief is ridiculous. You can think Thomas More refusing to acknowledge King Henry VIII as the head of the church was a ridiculous move and he should have just kept his head on his shoulders and signed the form. But that's not for the secular authorities to decide. That's not for judges to decide. They simply say, is the belief of the Little Sisters sincere? Has the government substantially burdened it? And neither of those things are debatable in this case. You can't deny that the Little Sisters believe what they say they believe, what they have pledged their lives to. And there's no plausible argument that the government hasn't substantially burdened their belief. If that was the case, why are they insisting that they fill out this particular form? Because it does exactly what the Little Sisters say it does, and that's precisely what they object to. Which then brings us to the least restrictive means compelling state interest analysis. It's not that Professor Sanders opened by saying, look, contraception coverage is a compelling state interest. We have the rights of women at stake. They're not arguing with that in the abstract. They're arguing, does it apply to us at the margin, our plan in particular, and if so, why have you exempted similarly situated religious nonprofits? Why are Catholic charities exempted in Pittsburgh but not exempted in Erie? Doug Laycock's wrong to say that this will tear down the entire structure of religious liberty law. What's required here is a rationale. A reason. If you can give a reason for why Catholic charities in one city should be exempted but in a different city shouldn't be, then Doug, he has this entire structure stay in place. But if you can't give that reason, then you have to treat similarly situated plaintiffs in a similar way. That's the argument that the petitioners are making. Likewise, they're saying, wait, if you're serious that this is a compelling state interest, why have you exempted 1/3 of all Americans from it? Why is it that 1/3 of all Americans are not on a health care plan? By law, they don't have to. Their employers don't have to provide this, but the nuns have to. Give us an argument for that, to say that it's a compelling state interest as applied to the nuns, but not a compelling state interest as applied to Exxon and Chevron and Pepsi. We haven't heard that argument. And then lastly, explain to us why using the Little Sisters of the Poor health care plan is the least restrictive way of ensuring that women have access to these drugs and devices. There are a panoply of other ways in which that the petitioners have identified that the government could ensure their access to these drugs and devices. We haven't heard a response from the government as to why they couldn't use those other options. This isn't legislating from the bench. This is the bench pointing out to the legislative and the executive branch that they have other means that they're other means available, and since they didn't opt for those means, they're in violation of the Religious Freedom Restoration Act. Thank you.
Just a couple of quick points, and I'm hoping we can still hear your questions as well. So I would just note Ryan did not grapple with my question. That is, what is the logical stopping point of an absolutist claim of religious liberty? Once again, his solution is to impose, well, there's a compelling interest. I feel that's a compelling interest to protect human life, so therefore that trumps the religious liberty claim. But other things where I don't think there's a compelling interest, it doesn't. And once again, what's a compelling interest is not highly susceptible to objective legal analysis. Ryan would probably say the government has a compelling interest in preventing discrimination against racial minorities, but not against gays and lesbians. I would differ about that. And we can get into a debate about that, but that debate would inevitably involve normative judgments. My point is simply that you can't identify a logical stopping point to an absolutist claim by interposing a later suggestion that, well, but that's not compelling and other things. That is in opposition to something, to an interest that's government compelling. Therefore, it can overcome any claim of religious liberty, but I don't see that in this case, he says. On Doug Laycock, my understanding of Doug Laycock did back off on some understandings about the technicalities of how the insurance policies work and the relationship between the insured nonprofits and their insurance companies, but he did not back off on the legal substance of his analysis, that the Hobby Lobby case does not require the kind of absolute deference to religious nonprofits, the religious nonprofit petitioners' religious beliefs that they say it did. Ryan made reference to paying the price, and sometimes there are eternal consequences to you for paying the price for your religious liberty. That is admirable. That's not deniable. It overlooks the fact, though, that in many cases of religious liberty, the consequences are not just for the individual. The consequences are not just for the government. The consequences are for the rights of third parties. That requires a different analysis. That requires that those rights also be taken into account. The legislative history of RFRA clearly shows, it says in the law itself, that in writing RFRA, Congress thought it was facilitating a balancing between religious liberties and the rights of third parties and the needs of the government. There is no evidence in the legislative history of RFRA that Congress anticipated the kind of unilateral, absolutist claims to the expense of third parties, no matter what, that are being put forward in this case. And finally, I can't explain, I really can't, why Catholic Charities in one city is exempted and it's not in another. If that's so, it seems crazy, and I don't know what the genesis of that is. But really what the petitioners are saying is that Catholic Charities, a $4.5 billion organization with thousands of employees, and religious colleges with many, many employees who are not religious believers or members of that religious denomination themselves, are similarly situated to churches and houses of worship, and therefore they should be treated the same way. Again, maybe there's a good argument for that, maybe there's not. It should be a matter of legislative judgment, and what the government is saying, what Professor Laycock is saying, and I think the better view here is that any resolution under RFRA of the claims in this case need to leave room for the legislative judgment that's necessary to provide religious accommodations, which are a good thing, I'm not denying that, but religious accommodations which are by no means required by the First Amendment, which exist by grace, essentially, of the existence of RFRA. And I think the concern is that if RFRA RFRA is abused with the sort of absolutist, extreme, one-sided perspective and claims that we're seeing in this case, that will do damage to the long-term cause of religious liberty. So, thank you.
I'm going to say two things briefly in response to that, because this is still amazing. There is nothing I have said this afternoon that was absolutist at all. I have described RFRA as a balancing test, and I have provided 5 different outcomes in which the rights of women to have coverage of contraception and the rights of women nuns could both be protected. So it's remarkable that Professor Sanders insists on saying that my position in this debate is the absolutist position, when I've repeatedly shown how we could actually respect the interests of both people in this debate using the balancing test. And he said, no, only one side will win. It's also remarkable that he's saying, I want to impute my normative judgments about abortion into this, when I said we have to look to the fact pattern of what the states have done. If the states allow 1/3 of people to be exempted from homicide laws, then we could say, well, maybe protecting life isn't a compelling state interest, and maybe we could allow this person to use it. But if they have more or less a uniform law when it comes to protecting the right to life, then it wouldn't be a case in which you could add one more exemption. Again, that's not me making a normative judgment. It would be me as a judge looking to the actual fact pattern of what have the states done. So in this case, if they've exempted 1/3 of all secular employers and they've exempted similarly situated religious employers, what is their justification for refusing to exempt the Little Sisters of the Poor? It's not my normative judgment. It's not the normative judgment of a judge. It's demanding a response from the government. And as Professor Sanders just admitted, he has no idea why they're doing it this way. That's exactly what the government had to prove to win this case.
I said I had no idea why Catholic Charities in one city is one way and another way. I can speculate that even though the grandfathering provisions, which may or may not be wise policy, may exempt up to 1/3 of insurance policies or employers, whatever the measurement is, there's good reason to believe that most of those exempted organizations, health policies, are actually providing contraceptive coverage. Ryan didn't say that 1/3 of them are allowed to not provide. Well,
yes,
they're exempt from the requirement, not that 1/3 of them are not currently providing it. As I said, the statistics I've seen indicate that 90% of private health insurance policies do cover contraceptives. And just to be clear, when I'm referring to absolutist claims, I'm referring specifically to the idea that my religious exercise is whatever I say it is, and no court may question that, and no court may question what I say is a substantial burden on that exercise.
Who has made that argument?
The
Because otherwise you're arguing against a straw man, which just seems inappropriate.
I'm admitting
who are you actually arguing with?
The briefs that I read in the case by petitioners. So
None of the petitioners made that argument.
They did.
Cite them, please. Cite them, please, because they would be interested to know this.
Sure.
And I think your students would be interested in actually reading the briefs to see if the petitioners actually have made the arguments that your professor is claiming they have made.
Yeah. Religious exercise is any act or omission motivated by religious belief. Law cannot treat some instances of religious exercise as more important.
And during your opening remarks, you said the court itself has said that.
Mm-hmm.
You said so. Yeah. Then, according to your theory here, the court itself is an absolutist on religious liberty.
The court has said that that courts cannot distinguish what is important or what is significant or what is substantial. Pre-RFRA, the court actually did get involved in deciding and evaluating that sometimes what a petitioner said was a substantial burden was not actually legally substantial. And scholars on both sides of this debate agree that RFRA has had the effect, has done more than what Congress thought it was doing.
You just changed categories.
You
went from the sincere exercise of religion to a substantial burden. Those are separate parts of the analysis. The quote you read was about the exercise of religion, and then you transferred to a conclusion about a substantial burden.
And
different prongs of the test.
What the petitioners are arguing is they're the same prong. The petitioners are looking at the Hobby Lobby decision and saying anytime a court purports to evaluate whether a burden is simply insubstantial or is too attenuated to be considered a substantial burden, that in itself is an inquiry into the logic, the substantiality, the significance of the religious claim. The petitioners are saying that the court in Hobby Lobby essentially conflated the two analyses, that it's not possible to do substantial burden analysis without also questioning the importance or significance of the religious belief
So what
itself.
petitioner says that the government has said that the nuns have their theology wrong. And Judge Posner made this very explicit in the opinion that he wrote for the Seventh Circuit. It was that they misunderstand their own theology. And that is what the Supreme Court in Hobby Lobby and what the petitioners in this case have said the government cannot do, because it's beyond the competence of secular authority to make theological judgments.
As the court has said since Reynolds versus Sims in 1879 and stood by in Employment Division versus Smith, it is not the court's business to tell a person or an organization whether or not they have their theology wrong or their belief wrong. The secular government is entitled to draw a line and say that actions can be regulated, conduct can be regulated. There's a line between religious belief and theology, and what that belief or theology requires the government to do or requires the government to prohibit the believer from doing when it comes to conduct. Those are two different
Of course
categories.
it can be regulated for a compelling state interest that's being pursued in the least restrictive way possible. So that's where your side of this debate needs to provide an argument and provide evidence of what the compelling state interest as applied to the Little Sisters that is being pursued and how it's being pursued in the least restrictive way possible.
So, and I'm not, so we should, let me make one more point, then we should.
One last point, and then we'll have maybe one question.
I'm not a litigant in this case. I'm not, arguing the government's brief. I mean, I'm not sure that, I think under the prevailing standard of RFRA, there may be a case that, the exemptions here are selective or have too many holes to qualify as narrow tailoring. That may or may not be the case. That may be a valid argument. What I think Congress should do or the administration should do is to fix those. Once again, Congress provided no exemptions here. The administration tried to do what it could to accommodate religion and is now basically being told it's violating religious liberty by doing so. And so I'm not here to flack for the government or to defend every last thing the government or Congress did or didn't do. I'm here to make the larger point that these are still breathtakingly broad claims about religious exercise and substantial burden that don't give enough attention to the claims and the legitimate interests on the other side.
All right, we have time for two questions.
So I have a comment first. So in regards to your other alternatives for birth control, as someone who uses birth control and have used it for years, your other alternatives burden women. Because if the women have to get on a second plan, if the women have to go somewhere else or have to get reimbursed, you're burdening my rights to use contraception. So I don't understand how you think that burdening my rights is okay for someone's religious rights not to be burdened. And my question is in regards to, and I actually externed last summer at the Seventh Circuit and got to work on the Wheaton College case. And so they were making the same points that by filling out the form that it was being triggered and that their plan was being used. And it was basically not accepted because their plan is not being used. A third-party administrator is appointed and provides that coverage for contraception that's not part of the plan. So I would like you to respond.
So the government has said that it is part of the same plan. They're not two plans, and the government's brief itself, and I can quote it for you if you want, because I actually have it here.
Okay,
the
I'll
government
get to
says
my
it
question
is
if
part
you
of
let
the
me
same
talk.
plan.
Thanks. So my question is, Judge Posner in the decision in Wheaton said, the college's notification to the government no more triggers the insurer's obligation to provide contraceptive services than a tortfeasor's declaring bankruptcy triggers his tortfeasor's joint and several liability for damages. So I wish you could
Perfect. Explain why he's wrong, or
or you could let me finish my question.
Sure. Explain. Finish the question. I mean, it sounded like you were wrapping up, so I wish you can explain why Judge Posner is wrong. I mean, half of the amicus briefs explain that. Judge Posner got this wrong as a matter of ERISA law. The government has no authority whatsoever to tell a third-party administrator what it has to do to someone else's plan, because that's not the way in which our healthcare system is set up. The government cannot simply commandeer someone's private contractual arrangements unless they fill out a form authorizing the government to do so. That's what's objectionable. That's why the government's insisting that they fill out this form. Because otherwise, and this is also why the government says it's the same plan. They're not two different plans that are being offered under ERISA here. It's one plan. So that's the hijacking part that both Kennedy and Roberts talked about during oral arguments, using the language of hijacking. And the hijacking cannot take place unless they fill out the form that triggers it. So, I mean, and this is half of the briefs mention Judge Posner by name, explaining where he got the argument wrong. To your first observation that as a woman this would place a burden on you, so the idea would be here that you have a right to have the nuns provide you with cost-free coverage of contraception. And they're going to say, all right, if that's the right, it needs to be balanced. And are there other ways in which you can receive cost-free coverage of contraception that don't burden the nuns' exercise of religion? And can we make this as cost-free to both sides as possible? So if the exchange work and it only takes 5 minutes to go online to sign up, and at the other hand it's the nuns' constitutionally protected, reinforced by RFRA, free exercise of religion, that's going to be the type of balancing test that the judges appropriately apply to a case like this.
Sorry, everyone, we don't have any more time for questions, but we'd like to thank Professor Sanders and Dr.